Tiffany Laura versus Experian Information Solutions. Hi, this is Consumer Protection Attorney Bill Clanton, and I'm here to talk to you about a new opinion from a district court. This is a trial court opinion out of the Northern District of Illinois, and it's a very interesting case because of the arguments that Experian makes in trying to defend itself when it messed up post-bankruptcy reporting. Okay, so to give you some background, I'd like to give you some background, go over the facts of this case, go over the court's discussion, and Experian's defenses. They're pretty bad. So let's get started. Okay, so CRAs must follow reasonable procedures to assure the maximum possible accuracy of your credit report. That is the rule. All right. Now, Tiffany Laura argues that Experian failed to use reasonable procedures in this case. And we'll get to their defenses, but just to give you some background about bankruptcy, most debts are discharged in a bankruptcy. Not all debts, but most debts are discharged in a bankruptcy. And Experian is required to mark debts as discharged when they get notice. The court in this case refers to the White order. There's a credit reporting case, White versus Experian Information Solutions, that is a big case. There was an injunction that came out of it. There's thousands of filings in that case. There's dozens of attorneys involved in it. It's a big ongoing case. Anyways, so the court, and I want to read to you what the court quotes. I want to read to you directly from the order, this order that refers to the White order. Okay, per the White order, within 60 days of notification of discharge, CRAs must identify the presumptively discharged collection accounts and indicate they were included in bankruptcy and bear no outstanding balance. This is known as a bankruptcy scrub. If a creditor reports a collection account after the initial scrub, the CRA must run another scrub to determine whether the new account is presumptively discharged. The White order does not specify when the second scrub, also called a look-back scrub, is required. Experian implements its bankruptcy scrub within 8 days of receipt of the discharge order. Experian contends, and Laura disputes, that it also updates collection accounts with a date open within 18 months of the bankruptcy filing. Experian runs its look-back scrub every other month for an 18-month period, it claims. Okay, so that's what is ultimately an issue in this case, is that follow-up scrub. So to the facts of this case. In June 26, 2019, Miss Laura filed bankruptcy. There was a utility bill she had that was delinquent. It was not included in the bankruptcy schedules. When you file bankruptcy, you fill out a long list of schedules that list every account and debt out there, and oftentimes bankruptcy lawyers use your credit report to fill this out. This was not on her credit report, and it somehow was not included in the schedules in her bankruptcy. Okay, so that was in June 26. September 26, 2019, Midwest Receivable Solutions opens an account for her. It's still not on her credit report. And then about 2 weeks later, Laura is discharged from bankruptcy. That discharge order gets picked up by LexisNexis, a big public records vendor, and they turn it over to Experian the next day, and it's reported into her credit file. 4 months after that, the collection agency reports a debt with an open date of September 2019 and a delinquency date of June 2019. So it should have been included in the bankruptcy. But the collection agency, Midwest, did not report that it was included in the bankruptcy. Experian, it was listed as due and owing. Experian should have picked up on this based on this White order, because I'll go back to the part that I read. If a creditor reports a collection account after the initial scrub, which just happened, which is what happened in 4 months after September 26, the CRA must run another scrub to determine whether the new account is presumptively discharged. It appears that Experian failed to do that, because if they had, they would have picked up this utility account and marked it as discharged, but they didn't. Okay, so Experian ended up reporting this debt for a total of about 5 weeks. And during those 5 weeks, Miss Laura was looking for a new car. She was going to buy a car, and she had 7 hard pulls, people checking her credit on her credit report, while this delinquent account, past due and owing, was being reported on her credit report. She did not have the benefit of the bankruptcy, which would have said it's a zero balance and included in bankruptcy. That would have harmed her credit score less. The bankruptcy reporting would have harmed her credit score less than an open account that is past due, okay, and in collections. Okay, so the 7 hard inquiries, she was unable to buy a car until she was able to come up with a large down payment, and I assume she got worse financing terms because of it. Okay, so that's the factual background. The court goes into legal standard, and then it goes into the discussion. All right. They start off by saying the FCRA, the Fair Credit Reporting Act, provides relief to consumers if a credit reporting agency reports inaccurate information on their credit report. They got that right. That's great. Okay. All right. So, and credit reporting agencies must follow reasonable procedures to assure the maximum possible accuracy of your credit report. All right. Laura argues that Experian failed to use reasonable procedures. Okay. And the court goes into the reasonableness of Experian's procedures. So Experian's defense, there's really 3 defenses they put forth. One, that it relied on the collector's reporting. 2, that it was in compliance with the White Order. And 3, that it's not liable for legal inaccuracies. Okay, the first one, parroting. The credit bureaus love to say that they can only rely on what the furnisher provides them, but that ignores their duty to investigate the information they're given. When you dispute something with a credit reporting agency, it's called a re-investigation because they're supposed to have already investigated the information that they are reporting. Oftentimes they don't, and they will tell you over the phone that they can only report what the furnishers provide them. But that's not true. They cannot report obviously incorrect information or information they know or should know to be incorrect. Like the White Order says that if they get a new report, they have to rerun the bankruptcy scrub. But their initial defense is parroting, and the court doesn't have any time for that. Okay, and that they were reasonable, and the court says that's a question for the jury. It's not a question the court can answer. It's a question of fact, not a question of law. Questions of fact have to be answered by the jury. Okay, then it says it was in compliance with White Order. The court again says that's a question for the jury. Now, the third argument, that it is not liable for legal inaccuracies. So Experian tries to characterize this as a legal dispute. And we've talked about this legal versus factual in other videos, but Experian tries to do that here, and they fail. And and that's a good thing, because this is a defense that the bureaus have been developing for years through different cases. I've done some videos on those cases, and there's some more to come. But this legal versus factual, the bureaus are trying to say that they can't make this determination because it's a question of law, not a question of fact, and they can only, they're not a court, they can't make any determination of law, they're not capable of making legal determinations about debts or answering questions of law in a dispute process. They need facts, they answer questions of fact. Okay, so here's what the court has to say about that. Okay, next, the court rejects Experian's argument that updating discharge accounts requires a legal determination that a CRA is not obligated to make. While CRAs are not obligated to come to legal conclusions, taking notice of a previously resolved legal dispute involves some knowledge of the legal impact of court decisions, but does not require the consumer reporting agency to make any legal determinations about the underlying claim. This is not a case where Experian need resolve complex legal issues. Experian can reasonably apply Chapter 7 bankruptcy discharge order to a consumer's credit file, as evidenced by the comprehensive White Order, under which Experian admits it should have assumed that a bankruptcy discharged the Midwest account. So they lose the legal versus factual argument here. which is a great thing because they're not able to further develop this defense. Okay, so the court goes on to say that to look at the damages, and the court ends up by saying that Laura's evidence of damages is weak, and the scope of her monetary damages appears narrow. The evidence is sufficient to survive summary judgment as to the denial only. So this is an interesting case where Experian's defenses failed, and it's good to show that the bureaus have strong procedures for handling post-bankruptcy information. There are so many errors that occur post-bankruptcy in post-bankruptcy credit reporting. The bureaus are equipped to handle it, but somehow they fail to, and they continue to fail to. Even with order after order and litigation, case after case after case, they continue to mess this up. If you have filed a bankruptcy and your credit report still has mistakes, if all of your accounts that were included in bankruptcy do not have a zero balance and say included in bankruptcy, then something may be wrong. Like I said at the start of this video, most of your debts should be discharged by bankruptcy. If they haven't been, then you need to look closely at your credit report. And if you need some help with that, give us a call. We're here to help you out, see what we can do to help you, and clear up any problems in your credit report. If we can't do that, then we can see if your case is a good one for litigation. Thanks for watching this video. I appreciate the time you spent watching. And if we can help, give us a call. Thank you.